You're all folks, and welcome to this webinar on Understanding 90-Day Trials. We really appreciate taking your lunchtime to tune in with us today. For those who don't know me, I'm Michael Prisk. I'm the Human Resources Consultant for Business Canterbury. So today we are joined, and it's my absolute pleasure to introduce Paul Mackay, who is the Manager of Employment Relations Policy of Business New Zealand, who we're a part of. So Paul's an expert. He's going to talk through 90-day trials at length. So we're going to look at the changes. He's going to talk about what this means for your business and how you can implement 90-day trial periods within the legislative requirements. Before we get into it, I'd like to acknowledge Business Canterbury strategic partners. So a big thank you for ongoing support from Westpac, Orion, 2 Degrees and University of Canterbury. After Paul's presentation, we will open up to your questions. So just a reminder, folks, that if you could use the question and answer icon to post your questions, and we'll look to get through as many as we can in the time allotted. So today's session is being recorded, so feel free to sit back and relax, and we'll make it available to everyone who is registered. So it's my great pleasure to hand over to Paul. Thanks, Paul.
Thanks, Michael, and welcome everybody. This topic is not necessarily a long one, but it's one that can certainly has its share of pitfalls as the past has shown. First, very briefly, why, in fact, even have 90-day trial periods? Well, the short answer is it gives an opportunity to take on people who have got less experience or little or no qualifications, possibly with troubled backgrounds, but which are no longer a problem. Youth, inexperienced people, older workers, people who have been out of the workforce for a long time, are all people who struggle to get back to the workforce because they don't have the kind of credentials or the recent experience or a CV that would enable them to get their first foot in the door as older or more experienced or current workers can. So this is an opportunity. And of course, one of the things that employers are always reluctant to take on sight unseen is the risk that if it doesn't work out, the cost of dismissing somebody because they're not working out is prohibitive. There are many pitfalls. The processes of going through grievances or the authority in the courts can be extremely expensive. And a lot of people shy away from employing these sorts of people because of those sorts of risks. There's also the question of in times when we have labour shortages, there's an awful lot of people out there who aren't necessarily prime candidates on the basis of their CVs, but the ability to give them a go is an opportunity for them. It's also an opportunity for businesses to fill gaps in their labour supply. So these are all reasons why 90-day trial periods are in fact very useful. We have had them in the past, of course. We had them for everybody prior to the last government. The last government restricted that back to small businesses, and the current government has now reenacted the ability for anybody to hire a person on a 90-day trial. So let's look perhaps briefly at how you do that. And there's a few basic rules. And if you don't observe those rules, the penalties can be high, as those few court cases that have been on this topic have shown. But the very first thing is 90-day trial periods are available for people who have not been previously employed by you. So in other words, you can't take a person who's in one of your jobs across to another job on a 90-day trial. This is for people who have never worked for you. So that's the first point. You can't take on somebody unless they have never worked for you. The second thing, and this is critical, is that before you take them on, the contract that you provide them must include a written provision that says that there will be a 90-day trial period or up to 90 days, that during that period, that it's clear in that provision that during that period the employer you may dismiss that person, and if you do dismiss them within that period, they don't have the right to bring a personal grievance for unjustified dismissal. So that's key. Having a provision in the contract before they start work is and which has those things in it, which is that it's there for a specified period, whatever the period you specify is, up to 90 days, that you can dismiss them during that period, and if you do dismiss them, they don't have a right. Those three things must be present in that clause, and if they're not, it could be found to be deficient if there's later a problem. The second thing is that before the person starts work, they must sign their contract. Again, one of the more famous cases illustrated that a person who signed their contract after they started work on their first day, in fact, was no longer subject to that particular provision. So in other words, you need to have that person sign their contract before they enter their premises on their first day. That's the only safe way to do it. The next thing is that having got them onto a trial period, you can then, of course, as the process suggests, dismiss them within that period. That says that, but the rule for that is that you must give notice of that dismissal or that termination of their agreement by virtue of that provision before the time is up. So before the time you've specified in the contract, let's call it 90 days for want of as a default, before that period is up. If you make that statement in terms of letting them go after that time is up, the provision is null and void. So again, time is of the essence. It is making sure that you do things in the right order that makes the biggest difference with this. The other thing is, and this is a trap for a lot, is while a person can't take a grievance for unjustified dismissal because they've been dismissed as part of a 90-day trial, it does not mean that they can't take proceedings under the rest of the provisions that relate to grievances. And there are a range of those. And I have some notes which I'll provide and can be sent to you that have those references in them. But the main point is that the other grounds for discrimination, for instance, are still live. And so there are cases, for instance, where somebody was told that they were going to be let go. It turned out that the reason that the employer was letting them go was because the person had a shake in their hand. It didn't actually have any relevance to their job, but the employer thought they had something like Parkinson's or whatever else and was going to be a problem in the future, so dismissed them. That went to the Human Rights Commission, and the Human Rights Commission found that to be an unjustified dismissal because it was on a prohibited ground of discrimination that was not itself unjustified dismissal purely and simply because of performance and their 90-day trial. So it's not purely protected. It is still open to other grounds of discrimination. There was another case, for instance, where a person stuttered and it annoyed the employer and they let them go ostensibly under the 90-day trial period, but it was found to be irrelevant to the job and therefore a prohibited grounds of discrimination. So those sorts of things have got to be carefully managed and carefully watched. The ground for dismissal under this is because they aren't up to the job. They're not performing the job that you think that you hired them, that you thought that they could do. They're not working out. That's the primary grounds, the only grounds that is safe to use this provision in. If we look at the other aspects, is a lot of the provisions of the ERA, the Employment Relations Act, relate to good faith, for instance, and other grounds. Good faith applies to everything except this, in the sense that where a person's employed, good faith or the good faith provisions require that the employer give reasons for dismissal. That does not apply here. So there are some exemptions from good faith provisions that relate to this. I've included those in the notes. There also is the provision to give reasons. In the Employment Relations Act, Section 120 says that where an employee is dismissed, that employee can request the reasons for the dismissal. That too does not apply in this instance, provided the provision is used properly. There have been a few cases around this over the time. I've made some references to those that would assist you if you want to delve into them. But the key thing is to get the main steps right. So if I reiterate those, before you can't take on somebody who's worked for you, who is already working for you in a different job. This must be a person who's never worked for you. It must be in writing, and that clause must state that they are being hired for under the provisions of the 90-day trial period, that the employer can dismiss them, and that if they are dismissed, then they cannot take a grievance for unjustified dismissal. And that if you are going to terminate them, you must give that notice before the period is up. Even if the actual date that they leave is after the period is up, you might have a notice period that has to be worked out. But provided you give them notice before the period is up, the 90-day trial period will stand. If you give them notice after the trial period is up, you will have in fact voided your ability to use that particular provision. So timing is everything, and keeping an eye on the time actually is where a lot of employers have come unstuck. They've forgotten how many weeks have passed, and all of a sudden it's almost too late. So the thing is, when you've got a person on a trial period, you're working with them. And in all respects, other than this, you've got to treat them as if they were any other employee. So training opportunities, health and safety briefings, whatever it is you do for your other employees, this person is an employee too for those purposes. The only thing that differentiates them from anybody else is this clause that says that at the end of 90 days or whatever period you specify, you can let them go if they haven't worked out. So treating them differently because they're on that clause itself falls within the discrimination provisions, because you are treating them unjustifiably. You're disadvantaging them relative to other people because of some unjustified reason. So it sounds simple. You can have them for 90 days, let them go, no dismissals. But hopefully I've illustrated that there are a number of areas in which these things can become complicated if you let them become complicated. If you work with the person from day one and clearly keeping an eye on as time progresses how things are working out, if you're talking with each other, there's your best environment for making sure these things work really well. And ultimately, as we hope, this is a way of giving all those young people, or the older folk, for instance, who have been out of the workforce, those people who don't have qualifications, those people who have otherwise struggled to find work, they're all fertile ground for employment if you find the right sweet spots. And this is a way of testing that in a relatively safe environment. I'll leave it there. And hopefully there's some questions. I'm certainly available for questions now, but also I'll provide through Business Canterbury the notes that I've just been talking to. And there's always the opportunity to ask questions via Business Canterbury anyway in the future, because as Michael said, Business Canterbury is joined with Business New Zealand. We're part of a network. We share our information. We support each other. So anything you ask that can't be answered directly at Michael's level can certainly come through to the likes of myself, and we can always help. So I'll leave it with you, and any questions I'm happy to address.
Hey, Paul, that's great. Thank you very much. It's always great to have your expertise. We've just got a few questions. First one, can an employer extend a 90-day trial period beyond the 90 days?
No, there's a statutory limit to that period.
Thank you. Next question is, does the 90-day trial period from the point of view of the unit of time refer to calendar days, or does it refer to working days, notwithstanding there's different and variable patterns of the working week these days? So the 90 days, is that calendar days or?
Calendar days. So basically you're talking 3 months.
Thank you.
Yeah.
So
90
Paul,
calendar days from the day of employment.
excellent. So Paul, hypothetical, if there are issues, say, with the employee trial period, say at day 30, day 60, should an employer leave all those performance concerns up to giving notice under the 90-day period, or should they be addressing them, for example, at day 30 and day 60? What sort of approach would you recommend?
I highly recommend being highly engaged with the employee throughout, because ultimately, if you are waiting and observing at day 60, day 30, whatever else, you're actually not working with that person to get the best out of them. If you've got a vacancy, you're as an employer, you don't want to be spending an awful lot of time on somebody you're going to eventually let go and start all over again on. So if your gut instinct, and let's face it, a lot of this first hiring decision will be a gut instinct to saying this person sounds like they're worth giving a go. I mean, I feel good about them. I haven't got the normal evidence that I would use to say this is a good hire, but I feel it's a good hire. Let's go for it. Why would you then want to waste that opportunity unless there are clear and significant indications of things that are simply not going to work out? At which point you're probably better to cut your losses early. You don't have to wait till the end of the period to dismiss the person. It is within the 90 days that you're allowed to make that decision. So at the end of the first week, if that person, for instance, has turned up on day one and hasn't turned up for the rest of the week because they can't be bothered, you're perfectly entitled at the end of that week saying, hey, look, this is just not working out. I'm going to let you go. Under this provision, I can. So it behoves employers to work closely with the person to communicate with them about how well they're doing throughout, because there's where the best value for both will come. If you wait till the end, the person has no knowledge of the fact that they've actually not done well. Who's lost? The employer's lost because they didn't put something right that could have been put right, and they didn't try.
That's a really great point. Thank you. So if just further on to that, if there are, say, ongoing issues like the day 30, day 60, should you encourage that employee to bring a support person to the meeting? And from an employer perspective, is that a good process, and from a good faith perspective to adopt, to say, look, we want to sit down and we've got some concerns about how you're going. We just want to give you some feedback, and if you want to bring a support person, that's fine. What's your advice in that situation, please?
I think it could be, sorry, pardon me. I think it would be highly useful. I mean, it really depends on the circumstance of the concern that the employer has. If it's a behavioural issue, for instance, it may be as simple as sitting down and saying, hey, son, do you realise that every time you say that favourite joke of yours, you're actually annoying a number of the staff who find it quite offensive?
Yeah.
That's usually sufficient. On the other hand, if it's simply saying, look, I'm getting to the point where you simply aren't the kind of person we need here. What we've got is your approach to this particular task, or whatever it might be. I am considering not finishing not completing, not going on with this. But I'd like to talk about it, and there's clearly some issues that you might feel more comfortable talking about that are not necessarily related to work. But if you're more comfortable talking about those with somebody present, then by all means do. And I'll give you an example. My own daughter, in her first job, was having a few issues. The employer called me and said, look, your daughter's having a few issues. We might not be able to continue this 90-day trial period, but there's a few things she's not able to sort of express clearly. Is there any chance you can come in and sit with her while we check this through? And I did, and it worked out. So those sorts of things are, it's very much a horses for courses thing, but it can be extremely useful. It is not required in the same way that the normal formal processes would if you're a full-time employee, but it can be extremely useful. But again, this is about what will give the best value, being human, what will give the best value to the employer in terms of uncovering something that, if solved, would actually create a decent future, or uncovering something which, now known, means that we should not actually be continuing with this process.
Yeah, no, that's excellent. So, Paul, another question from attendees, and appreciate them coming in, folks. Immigration New Zealand advised that 90-day trial periods are not to be used for migrants. Is this the case?
Well, the law is not specific about that. It is an employee is an employee is an employee. So that is a matter, I think, and I'm not 100% clear whether the immigration rules would overlay that. But at this stage, the Act is non-specific as to who it can be applied to, other than the fact that it has to be somebody who's never worked for you.
Yeah, no, I understand that to be the case. Is there any other exceptions? For example, is it likely that unions would seek to prohibit the use of 90-day trial periods and collective agreements, for example?
Oh, that's certainly possible, and it's been the case in the past as well, where unions have sought to include clauses in collective agreements that say that that 90-day trial periods, as provided for in the Employment Relations Act, shall not apply here. That's entirely up to an employer and a union to bargain and agree. But if that were to be the case, then the ability of that employer, effectively the employer is waiving their right to use the statutory ability if they sign a clause like that in a collective agreement. But it is certainly possible, and it's certainly been done.
Okay, no, thanks for that. Another hypothetical situation. Let's say you're getting towards the end of the 90-day period and the employer's deliberating as to whether they continue the trial employee, and further into and confirm permanent employment. Can you move from a trial period to a probationary period?
Well, technically, yes. The provision for a probationary period is now a little confusing in the sense that probation used to be what we called a trial period. And if I go back in history, before 1988, the state sector, for instance, had probation periods where if you joined the public service, you were on probation for 1 year, during which time you could be let go and there would be no comeback whatsoever for the department concerned. That probation period could be extended to 2 years. So that was basically a 90-day trial period of up to 2 years. What that has been lost in the sense a probation period doesn't have any ability to do anything at all in relation to letting a person go. So all it really does is provide a framework within a person might be more closely supervised. So if you read the provisions in the Act, it suggests that there will be quite a close interaction between the employee and the employer during that period of probation, where it could be contractually agreed that we're going to stay on top of you for the first 6 months of your employment, and then we'll stand back after that. But that gives the employer no more right than with any other employee in relation to dismissal or any of those other punitive options that they might have. Right. So it's a bit of a wet rag, really, that probation period now. It used to have strength, but with the advent of 90-day trial periods and pushing back on traditional probation, it's one that's very rarely seen in contracts now, because it tends to relate more to a supervisory period within the period of employment rather than the ability of or the waiver of any rights.
Thanks for that, Paul. So, Paul, what would you see as the biggest issues or the most important risks that employers need to be aware of if they're contemplating the use of a 90-day trial period? Just in summary, what are the things they really must get right to avoid any legal risk at the end of the 90-day period, or when the person is dismissed under a 90-day trial period?
Sure. Well, on the checklist, as I mentioned before, but worth repeating, is they can't have worked for you before. They must sign that provision that is required to be in the contract before they set foot in the door on their first day of work. And if you're going to let them go, you must tell them that you're going to let them go before the period that's specified in the contract is up. Those are the main ones. Right. If you get those ones right, the rest is all about managing the edges. But you cannot survive, or you cannot use the clause or the ability to have a 90-day trial period if you don't take on somebody who's never worked for you. You don't have a clause in the contract. They don't sign it before they start work. And you don't tell them before the period is finished. Those things will kill that clause dead for you. The rest will all, other areas may cause you difficulties, but they won't kill the clause per se.
Right. Thanks for that. A shorter question: can you use a 90-day trial period for employees on fixed-term employment agreements?
Can't see why not, but ultimately it's a bit of a nonsense, really, because the person's going to be going anyway at the end of the fixed term.
I guess it depends how long the fixed term is, really, isn't it?
So, true, yes, it does. But if a short-term fixed contract allied with a 90-day trial period seems to be a bit of a nullity, if not overkill. So I would suggest, yes, it's possible technically, but why would you if the person's going to finish anyway?
Okay, thank you. Perhaps one last question. So, can employers pay in lieu of notice?
Yes,
so they want to get move, not going to continue the trial employee into permanent employment. Can they pay in lieu of notice? Or yes. Is there some particular requirements around that?
No, they can still pay in lieu of notice. The only requirement is that the notice is given prior to the expiry of the trial period. That's the only key requirement. If they've got a 2-week notice period and you tell them 1 week before the end of the notice period that you're going to let them go, you could pay them the 2 weeks rather than having them stay for another week beyond you telling them.
So should there be some wording around pay in lieu of being required to work out the notice period? Is that the safest way to do it, or is it pay in lieu of notice sufficient?
Pay in lieu of notice is technically sufficient, but many people may find it helpful to be clear in the contract saying that should we give notice, should we give you to terminate your employment during this period, we will pay you
And we're being required to
what is
work
due
out
in
notice
notice
period.
in lieu of you working out any
Right.
remaining period. So in other words, you're almost saying to a person, if there's a 2-week notice period and they're 4 weeks into a 90-day trial, and you say, no, I'm going to let you go, they're effectively going to get 2 weeks pay for you to let them go, because
So
that's the
would you
notice.
recommend, say, 1 week notice and a 90-day trial period
Well,
agreement?
again, the kind of rule of thumb is a notice period is equivalent to the pay period. That's the default provision. If a contract has no notice period in it, the courts will often look at what's the pay period. So if they're paid weekly, then a week's notice might be the appropriate form, fortnightly, monthly. But many contracts, of course, have a specified notice period, including some quite long periods. It pays to be on the shorter end of this, but clearly you're looking at a person who's potentially not going to be with you very long. Having a long pay period, a long notice period, makes no sense.
Yes.
And typically 90-day trials are going to be in jobs that are usually paid at the weekly or fortnightly level anyway.
Great, thank you for that. We've got no more questions, folks, so we'll close it off. So, hey, a big thanks to Paul. As always, your expert knowledge is much appreciated. So, thank you for all the attendees who are online, much appreciated. Some of the names I recognise. So, please feel free to follow up if you have any further questions or queries. And as Paul said, he's going to make available to yourselves a checklist, which we really appreciate. Just a bit of a plug for Business Canterbury. We are in the process of developing some quite comprehensive resources around the 90-day trial periods, including checklists, employment offer letters, some case law summaries, which we'll be making available to members. And if you have any further queries around this, then if you haven't got my contact details, you can send an email to michael.prisk, michael.prisk@cecc.org.nz. So you're very welcome, and thanks again for giving up some of your lunchtime today on this beautiful late autumn day in Christchurch, in Canterbury, I'm sure. So thank you, and we'll close off the session. And been great to have you, and you too, Paul. You have a great rest of the day. Thanks very much, as always. Make yourself available. Thanks, folks.